Welcome to my channel, All for Health with Jane. Family, the Thabo and Nandipha Magudumana case is back in court. Just to remind ourselves, in the previous hearing, that's when Thabo made a request complaining that he is not well treated at the Kgosi Mampuru maximum prison, and he's being isolated. He even went to an extent of requesting the judge that maybe he needs to sentence him, give him a death sentence. And the judge said, no, it's not upon him. He cannot do that. He cannot bring back a death sentence in this country when it has been abolished. And the reason why he was complaining that much, it was because his lawyers were continuing to withdraw. The reason why they were withdrawing, they said it's because it's not easy to deal with Thabo Pester. Whenever they want to consult with him, it is a challenge. Hence, at the end, they had to withdraw as well. The magistrate advised Thabo Pester to present that complaint through a lawyer. And then maybe before we talk about Thabo Pester's lawyer, another thing that happened today in this court, because on that day, Thabo Pester did not have a legal representation. So because of that, the case was postponed to today. Now, today, the 24th of July, 2024, when they thought they were going to have a trial today, the case was postponed again to the 31st of July, 2024. Now, the reason for postponement was that accused number 3 and accused number 6, by the names Mr. Matswara and Mr. Makhotsa, they did not have their legal representation as well. Their legal representation withdrew as well because of a lack of finances. So the reason they could not pay him made this lawyer to withdraw from being their legal representative. So, okay, then because of that, a case where it has many accused persons, the challenge is whenever one of them does not have legal representation, then everything stops. There is no way they can continue without a person having a lawyer to represent him. So today, as we were thinking that the case would go on, accused number 3 and accused number 6, their lawyers withdrew. And after withdrawing, then the case had to be postponed. Family, let's listen to this short clip where their lawyer was telling the court that he is no longer going to represent them. Let's watch.
My Lord, the way I understand it, I was not here the previous time, but this matter is set down for a pre-trial.
Yes.
The state is ready to proceed with the trial, my Lord. So maybe that the legal representatives just can confirm whether they are ready to proceed and if they are placing proper funds.
Yes, the matter was inter alia postponed to give accused number 7 an opportunity to instruct a legal representative. Mr. Moilwa is here on behalf of accused number 7. And then I think Mr. Muriri also raised an issue the last time around. Maybe let's start with you, Mr. Muriri.
So, but please, indeed, so previously we had indicated that there were undertakings that funds would be forthcoming. However, said undertakings had not been fulfilled. As things stand, I remain outside financial instructions, and this would then be my application that I withdraw as the legal representative on behalf of accused number 3 and 6 respectively.
So that is with regard to both your clients?
That is with regard to both my clients. Mr. Matswana and Mr.
Mr.
Mahotsa.
Mahotsa. Yes, thank you, Mr. Mururi. Let me just hear from them. Mr. Mutswaro and Mr. Mahotsa. What is the position now? Mr. Mururi says that he has not received any financial instructions from you. Otherwise, you have not paid him.
That's for, however, we apply for,
You will apply for legal aid. You're also going to apply for legal aid, rather. And you therefore don't have any objection if Mr. Mururi withdraws. Both of you. Thank you, Mr. Mururi. Your application is granted.
that's the what pleases me.
Thank you. Yes, Mr. Moelo. On behalf of number 7.
Family, the next clip we are going to listen to Thabo Bester's new lawyer by the name Mr. Muelwa, as he is presenting, or maybe formally presenting Thabo Bester's complaint to the court, and even the advice that this judge is giving to him. Family, let's watch.
Yes, Mr. Moelo. On behalf of number 7.
The court, please, my lord. Indeed, as I've said, or as we've discussed in chambers, we have an instruction to move an application. Unfortunately, I just got failed by my device here, and I'm informed that there are no plugs that are closed. It's unfortunate. This is like 2024, but we find ourselves in this situation. So I'll just work around with what I have and rely on my memory.
Yes.
Yes, we rely on these devices. So the application that we're going to move, my lord, it's literally to safeguard the interest of accused number 7, which is primarily the right to have legal representation. So without that right, nothing can move. Trial or pre-trial, absolutely nothing can move, because our responsibility, we don't owe him only the responsibility to protect his interest, but we also owe the responsibility to this court as officer of the court for the administration of justice. So that's why that aspect should be moved first before anything else. And as such, the accused previously tried to move this application. Last time, there was something, obviously, it excited the media. But in that endeavor, he was simply saying, my lord, I can't do anything without consulting with my lawyers. And possibly, in the treatment that I'm receiving, you might not have accused number 7 in the future. Either because of psychological problems, because we need him, all of him, physical, mental, everything. So if he is kept by the state machinery, which is the correctional service, in the manner that obviously I'm not going to deliberate, it's there in the papers, it's going to be deliberated in due course, would have wished to deliberate today. We might not have him mentally intact. So, and that itself, my lord, it's something that needs to be dealt with expediently. And we also responded to that expedient, to that expedient requirement of that type of endeavor. So what we did, we consulted with him several times with the restriction that are imposed by the correctional service, and some of the restriction obviously ended up in some of us catching food, because we consulted in extremely cold conditions there at the correctional service center. So we don't want to have him not here in court and his legal representative because of the conditions there. So we drafted an application, founding affidavit, served on the state, served on the prosecutor, served on the correctional service, served on the head of correctional service, because some of the prayers that we seek, it will need the court to order them to do or not to do certain things. Now, what happened in Chambers was some sort of like an engagement as to whether this court would hear this application or it should go to some court, motion court, or whatever court that specializes in that. Our view is that this is the court that specializes in what we are about to do. Because it has nothing to do with anything else but his right to a fair trial. And a fair trial is not him taking the stand and start giving testimony. Fair trial includes legal representations. So if that is threatened or has been violated, this court itself must intervene. That's why this court can intervene, that now the correctional service, as they are here, because this is not for Simambo, it is the court, can order them to remove the shackles. He is in shackles now. As you see him as a criminal, but no, he's not. He's an accused person. He must enjoy the presumption of innocence. So when you see someone being brought like this in court, you have the impression that here is a villain in court. We don't want that. We want your lordship to see him as all other accused that you see here. So that on its own does not need some head of correctional service. He is before your lordship, that you can do. Does not need us to go to any other court. Literally, the lordship, with utmost respect, can say that this creates a bad perception to the accused person, that there is accused person that are seen as criminals, there is accused person that are seen as accused in a true sense. So that is part and parcel of what is going to be the motivation. Why no any other court but this one must hear this application. But because, my lord, administratively we had challenges that we could only serve this application yesterday at 3. What that means is that inevitably, even if your lordship wanted to get this application, it's practically impossible, because we raise serious issues, legal points that need to be ventilated. And that's why in the service of the application we omitted a notice of application or a notice of motion, deliberately, in the sense that there was no one that would have been able to come here. But as a matter of courtesy and to avoid ambush, serve the affidavit, and we say that in our notice of application, we will obviously seek directives. If we had enough opportunity to deal with this application, we would have prescribed the time frame, because there's no rule in this particular court that says that this one must file the application after 10 days. Not rule 612. That's not how criminal proceedings are conducted. Try to fashion or find the best possible solution under the circumstances to protect the right of the accused. You don't become the slave of the rules that are not applicable. So we would have prescribed and motivate why we prescribe as such. But because time did not allow, he then says that we will try to put it before the court and seek directive that other parties that are not here, how can we possibly remedy this and prescribe the time frame that would, in light of the circumstances, ameliorate the prejudice that is suffering. Because now, if we then say that let's go with what it's done in the motion court and prescribe those time frame, it defeats the purpose of what I've said. We're going to come to a person who's mentally short, or physically or otherwise. So that's what exonerate himself. It could be that the truth is to implicate himself, but it must happen now. It must not wait for a future event and allow the violations to happen. So I did not want to say this, but because there was that pre-engagement in chambers, I spoke to the accused and I was instructed as such that I must place this on record, that their instruction and indeed the legal advice is to have this application had. If there are any challenges, or legal variances, this can be ventilated. So my suggestion would be that if there's any legal variance The ventilation of such can be decided, the date of ventilation of such can be decided by this court. Because this court cannot decide that I'm not hearing the application because there's a particular heading in that application. You must hear the substance of that application to make a determination that go to a tax court, go to this particular court. It must
Why a
first,
tax court?
in my previous life, I was doing tax law.
Well,
So
let's stick to your current life.
I beg your pardon?
Let's stick to your current life in criminal court.
I'm just giving you an example of other, but the point that I'm making, my lord,
Yeah.
and let me just say these proceedings are serious. The point that I'm making is that the court must, at least this particular court, hear the basis thereof and allow every party. It can even say that before I decide whether I want to hear it, I'm calling parties specifically to deal with this particular aspect. That's what I wanted to say, and then if there's anything else we hear. But in respect of then, thereafter, because your lordship also mentioned the issue of time frame, that there are other matters we should try to limit lengthy engagement so that your lordship can proceed, is that after this, we've informed our clients that we're going to consult with him. And let me start by saying that in that respect, we're indebted to your lordship for intervention. For the very first time, I met my client for the very first time. In Hosimampura, I was meeting him behind glass and telephone and stuff like that. This is a consultation that we envisage. And I hope that after this court, we're going to get more information so that we can move forward. So that is going to happen after the postponement of this. But my request is that we be given an opportunity to argue this particular point of jurisdiction after your lordship has considered the best possible way that it can be done.
Yes, Mr. Moela, obviously I do not know what the basis of the application is because I have not been privy to the papers. Ms. Bester has already indicated in chambers that they are going to oppose the application and they have not yet filed any answer to the papers. So let's hear Ms. Bester.
My Lord, if I may. First of all, my colleague is a junior colleague, and as far as I know, he was supposed to put it on record because Mr. Miche, senior counsel, phoned me yesterday and also about 3 weeks ago that he's going to appear for him. So if my learned colleague didn't see him, Mr. Bester, then I can understand why he wants to do it today. First of all, I want to answer on that. The state is the prosecutor. I'm presenting the state. So he can't serve it on the prosecutor and the state. Nothing was served on us yet. The documentation that I received yesterday by means of an email was unsigned affidavit, and I was informed via email by Ms. Nana Reid that they will serve the papers today. That is an application, a motion application. There are certain rules for that. We cannot hear the application today because according to that unsigned paper, correctional services are cited, CMAX are cited, and I think the Minister of Police. So the audi et alteram partem rule is applicable not only to the accused but also to the rest of the parties. And with all due respect, my impression is that my learned colleague does not understand the difference between an application for notice of motion and what he wants to do now. This is really not the way he's supposed to do it. Then he must make his mind up what is he going to do. But we can't do it like that. Then, my Lord, it's not only accused number 7 who's got certain rights. Accused number 1 is in custody. The other accused are there. I understand from my learned colleague, Mr. Mashini, they are ready to proceed with trial. But the state is also entitled to say that we are also ready to trial. And we are ready for trial since last year, October. And then what they didn't put on
But
record.
do they receive similar treatment at the respective prisons? I know she is at Kroonstad, he is at Hosimampura.
But the women are in Kroonstad.
Yeah.
And we cannot interfere as to where they must be kept. I mean,
No, not where they are kept, but I think Mr. Moela is referring to access to his client.
My Lord, I
That's why I'm
cannot...
asking you, is there a situation of accused number 1 being treated differently to accused number 7, since you refer to accused number 1?
Then the correctional services must answer to that. I'm not a party to that. Really, I can't answer on their behalf. But what they didn't put on record, I received also Friday another application that was brought by the accused in person, that he was abducted from Tanzania and so forth. They didn't mention it now. Mr. Mishe informed me that they're not going to handle that. He's going to do it in person. Because really, we must start to move on and proceed with this matter, because it is in everybody's interest that we can proceed with this matter. Thank you, my Lord.
Mr. Moela, I heard you referring to jurisdiction now. I hear Ms. Bester also referring to jurisdiction in a roundabout way. Are you saying that the application that you want to move relates to the jurisdiction of this court to try accused number 7? Or what is it?
Yes,
because that you can do at plea stage.
Yes.
The Criminal Procedure Act makes provision for that.
Yes, my Lord. You know, when we prepare this application, let me just say that it's informed by research. That's first thing. And what is going to speak there, it's the case law more than my voice. Obviously, the case law is written. I must be the one reading it. But literally, this is not the first case, and it's not going to be the last case to hear this application in a criminal court. There's a plethora of case law in that respect. And in no way did I stand here and I said I want to argue the application. It would be absurd for me not to give an argue. I mean, every law student, even the one that are just studying certificate in law, they know that the outer principle is the foundational value of our constitution. I can't move an application without giving people an argue. What I said is the pre-engagement that we had in chambers, that after having consulted with my client, that this is then the instruction. So the issue of jurisdiction, I even suggested, gave the solution. I don't understand whether there's going to be selective listening and selective answering. I gave a solution that we can come and argue this particular point. And truly speaking, I don't know how it's going to be defeated in the respect of jurisdiction. It might be defeated in merits, but in jurisdiction, my Lord, I can literally, on the day, take less than 5 minutes to deal with this point. If it can be argued now, it can be argued now.
I prefer not,
Yes.
because the people that I'm told you have cited or institutions are not before me yet.
Yes.
And I would like to hear what they have to say about your application. The prosecutrix informs me that she has received the papers yesterday. She says it's a notice of motion, but they have not yet answered. I'm told that the Department of Correctional Services, Minister of Police, and the Commissioner are also cited, but I don't even know whether the papers were served on them. So, for all intents and purposes, Mr. Moela, that application is not before me. Let us wait for them to answer and for you to reply, and a court date will be allocated for the matter to be ventilated. So, for all intents and purposes, now where we are, there is no application before me. I have not seen your papers, and I'm not interested in seeing them now until after all sets of affidavits have been filed by all people who have a material interest in the matter. You indicated to me that you want an opportunity to consult with your client, which opportunity I gave you. And you also intimated that you might request that the matter be postponed to sometime maybe in next week or so. I would want to hear from you now, when it comes to the postponement, what is the situation? Whether Mr. Mshe will be arguing the application or whether he will be conducting the trial on behalf of accused number 7 is at this stage neither here nor there when it comes to these proceedings. You are satisfied that in order to protect your client's rights, you have consulted with him And if not, I will give you another opportunity to consult with him in the cells after I've postponed the matter. We have facilities for that. You can consult.
Thank you, family, for watching to the end. Hope you enjoyed this video. Please do not forget to like this video before you leave and subscribe for my channel if you haven't done so yet, family. I love you very much. Thank you. Bye, family.